You're listening to the Study Legal English podcast, the world's first legal English podcast, helping lawyers and law students become fluent in legal English. Hello and welcome to episode 68 of the Study Legal English podcast. I am your host, Louise, and today's episode is all about what happens in a criminal trial. In the last episode, we looked at the pre-trial hearing. We learnt that all criminal prosecutions start in the Magistrates' Court with a pre-trial hearing, and at this hearing, a range of preliminary matters are dealt with. What happens next depends on the type of offence allegedly committed and whether the trial takes place in the Magistrates' Court or the Crown Court. This is the topic of today's episode, and I'd like to point out that I'm talking about the procedure in relation to adults aged 18 or over, as the procedure is slightly different for young people. So let's get started. Firstly, I'm going to highlight some general rules which apply to all criminal trials. Generally, the criminal trial takes place in open court, meaning that members of the public can attend. And a trial only takes place if the defendant has pleaded not guilty or remained silent in the pre-trial hearing. Why is this? Well, because the point of a trial is to settle a dispute, to find out which facts are really true. If the defendant says he is guilty, he is saying the same thing as the prosecution, and therefore there are no disputed facts which need to be determined. So if a defendant has pleaded guilty, the case will proceed to sentencing without a full trial. Another point worth mentioning is that England, being based on the common law, has an adversarial justice system, which means that each party involved in a trial is responsible for stating their own version of the facts of the case in a sort of battle. The judge or magistrate hears both sides and ensures a fair trial before reaching a verdict or directing the jury who deliver a verdict. This is quite different to the inquisitorial system which is used in civil law jurisdictions. In the case of an inquisitorial system, the judge is more involved in collecting evidence and even investigating the case. So now, let's look at what happens in more detail. Firstly, we will look at what happens in a criminal trial in the Magistrates' Court. The Magistrates' Court is an inferior court of first instance which deals with over 90% of all criminal cases from start to finish. The Magistrates' Court will try all cases involving summary-only offences, as well as some either-way offences, if they have been allocated there. In the Magistrates' Court, cases are either tried by magistrates or district judges. These are both known as justices of the peace. And in this court, there is no jury. A jury is a group of normally 12 randomly selected members of the public who receive a jury summons to attend court. The jury are triers of fact. It is their role to decide what facts are true and to deliver a verdict of guilty or not guilty based on these facts. Because in the Magistrates' Court there is no jury, the judges or the magistrates act as the triers of both law and fact. This means that they deal with and decide how to apply the law and what the facts of the case are. Now, I've said this before, and I'm going to say it again because it's quite an important point. Do not confuse the word magistrate with the word judge. In England, these are not synonyms. Magistrates are lay persons. This means they do not have specialised knowledge in a particular area. They are not normally legally qualified, although they do receive training for their role. And they are also not paid a salary. Instead, they are volunteers and they can only claim expenses, for example, travel costs. Magistrates normally sit together as a panel of 3, which is sometimes referred to as the bench. They hear the less complex cases in the magistrates' court, and they are assisted by a legal advisor or justice's clerk. The legal advisor or justice's clerk is normally legally qualified and helps the magistrates with information about law and procedure. More complex cases on summary trial, this means trials in the magistrates' court, are tried by a district judge. The district judge is a qualified lawyer who works full-time and for a salary. Unlike the magistrates, he or she can sit alone in the magistrates' court. So, what normally happens in a summary trial? Well, the first thing that normally happens is that the justice's legal advisor reads out the allegation to the defendant, explains it, making sure that the defendant understands it. He or she will also explain the court procedure and ask for the defendant's plea. Remember that the plea is the defendant's response to the charges, either guilty or not guilty. If the defendant pleads guilty, the court may convict the defendant without hearing any evidence and proceed to sentencing. If the defendant pleads not guilty or remains silent, the trial will begin. Or if the defendant has already entered a plea of not guilty, for example, at the pre-trial hearing, then the justice's legal advisor will ask the defendant to confirm this, and the trial will then begin. After this initial part of the trial, there are 4 main stages. The first part is about the prosecution's case. Here, the prosecution gives their opening speech where they summarise the prosecution's case, identifying the relevant law and facts of the case. This is followed by the prosecution introducing evidence to prove its case. The prosecution may call witnesses to give evidence, and all witnesses who are called must take an oath or affirm. This means they promise to tell the truth. The first witness the prosecution calls is normally the complainant. The complainant means the person who has made a formal complaint, such as the victim of the crime. The prosecution asks this witness questions in what's called the examination in chief. This means the prosecution asks them questions to elicit the prosecution's version of the case. Next, the defence has the opportunity to ask the witness questions. This is called cross-examination. The purpose of this cross-examination is to put the defendant's version of events to the prosecution witness and to cast doubt on the witness's credibility. Following this, the prosecution and the bench have the opportunity to re-examine the witness, and this part is called the re-examination. If at any point throughout this process the witness can't remember something, parties are allowed to show witnesses certain documents in order to refresh their memory. In other words, to help them remember. And there are various rules related to the kinds of questions a party can ask. They are not allowed to ask irrelevant questions, and a party cannot ask a leading question to its own witness about something in dispute. Listen to the following questions. Number 1. John was carrying a knife, correct? Number 2. What was John carrying? Which one do you think is a leading question? That's right, the first one. I'll read it again. John was carrying a knife, correct? A leading question is a question which prompts the respondent to answer in a specific way. It directs them to an answer. The first question I asked contained the object, the knife, which could make the respondent think that they saw a knife when actually they saw something else. So, moving on, after this examination process, the witness is released from the witness box and the process can happen with a different witness, such as an expert witness. The witness box is the place in court where a witness stands to give evidence, and an expert witness is somebody who gives an opinion on any matter which falls within their expertise. Other exhibits can also be presented. An exhibit is a document or other thing which is presented as evidence in court. For example, if parties agree on certain facts, witness statements can simply be read out with no need to examine or cross-examine the witness. When this stage is finished, the prosecution will indicate this by saying something like, "That is the case for the prosecution." And now we're going to turn to the second stage, right after this short break. I'm interrupting the Study Legal English podcast for an important announcement. Do you want to get ahead in legal English? If you'd like to make faster progress with your legal English, you can sign up as a Podcast Pro member and get access to transcripts, quizzes, and much more. You can track your learning progress and even earn course certificates. Take your legal English to the next level. Visit studylegalenglish.com/podcast-pro. Great. So, what happens in a criminal trial at the second stage? Here, the defence may make a no case to answer submission. Sometimes this is referred to as a half-time submission because it is a proposal made halfway through the trial. A no case to answer submission is an application made by the defence to the judge or magistrate asserting that the prosecution's case is too weak to be able to convict the defendant. If the submission is successful, the magistrate or judge will find the defendant not guilty. The defendant will be acquitted on the ground that the prosecution's evidence is insufficient, and the defendant will be free to leave. If the submission is unsuccessful, however, the process will continue to the next stage. The third stage begins with the justice's legal advisor explaining to the defendant that he or she may give evidence. The defendant has a choice. They can simply remain silent, but if he or she does this, it could make a court quite suspicious, and the court may draw a negative inference from the defendant's failure to give evidence. On the other hand, if the defendant chooses to present evidence, they follow the same process as the prosecution does when they present evidence, except that the defence does not make an opening speech. And, of course, the main witness is not the complainant, Instead, here it is the defendant. After following this process, the defence indicates the end of their evidence by saying something like, "That is the case for the defence." Both parties are then invited to introduce further admissible evidence, and this could be to rebut any evidence that has already been given. To rebut means to nullify or to void or to prove something false. Then we move on to the next stage. Stage 4 is known as the closing. If the defendant has legal representation, then the prosecutor may give a closing speech. Here, the prosecution tries to convince the magistrate or district judge that the defendant is indeed guilty. This is followed by the closing speech from the defence, who is always entitled to give a closing speech, even if the defendant does not have legal representation. In the closing speech for the defence does not need to prove that the defendant is innocent, but they must highlight weaknesses in the prosecution's case to show that the magistrate or district judge cannot be sure that the defendant is guilty. Remember that in order to convict a defendant in English criminal law, there is a very high burden of proof. The defendant's guilt must be proved beyond reasonable doubt. This means that we must be sure of the defendant's guilt. After the closing speeches, if the case is being heard by lay magistrates, the magistrates will receive legal advice from the clerk or legal advisor, and then, if necessary, they will retire. Now, this doesn't mean that they'll finish their job because they've suddenly turned 65 or reached retirement age. No, it means that they leave the courtroom in order to reach a verdict in private. After this, the court will deliver its verdict. This means that they say the verdict out loud in court. If the court finds the defendant not guilty, they will acquit the defendant, and the defendant will be released immediately. If they have found the defendant guilty, the magistrates or district judge must give reasons for this verdict, and the trial will proceed to sentencing. Great, so now that we've listened to all of that information about the trial in the magistrates' court, I just want to make a few points about the vocabulary I used. Remember that prosecution and prosecutor can both refer to the person or body that is instituting criminal proceedings against the defendant. Prosecution can also refer to the process of prosecuting and the case which is being presented by the prosecutor. Similarly, defendant refers to the person being prosecuted, and it's used in both civil and criminal law, whereas prosecutor and prosecution are only used in criminal law. Defense has a number of meanings. In this episode, it is used to describe the lawyer representing the defendant or the case which represents the defendant. Great, so that's the end of today's episode. Before I go, I'd like to say that I found quite a cool and free resource when I was researching this episode. It's called You Be the Judge, and it's developed by the UK's Ministry of Justice. Basically, it's a website where you can watch a few videos about a criminal trial and you decide whether or not the defendant is guilty and what sentence you would pass if you were the judge. I recommend that you check it out. It's quite a fun resource. You can find it at www.ybtj.justice.gov.uk. And again, another helpful resource that I used, which is free, is defence-barrister.co.uk. Remember, that is the website of criminal barrister superstar Christopher Kesling, who I interviewed back in episode 64. So, as always, Podcast Pro members can find extra resources at studylegalenglish.com/episode 68. And I will, of course, leave details of all of these links in the podcast notes. So, thanks for listening and see you next time.